noches. Good evening, everyone. Happy Friday. We are excited. The weather is changing. We want to thank everyone that's on the line so far with us. We have, I believe, it's 16 attendees. I think we should wait a little bit to allow the other folks to join in. But I wanted to first and foremost thank everyone that joined in on time. Apologize for us coming in just slightly a little bit late. And I think that we got some great program with you guys today. As always, I thank you guys for joining us on a Friday. We believe that education is power, and the fact that you're making this your business to learn about MCIs is big because a lot of the tenants do not know what MCI is. A lot of tenants do not find out or don't even know what the word stand for. They just say MCI. And only when they're affected do they actually reach out to organizations like Palante. So for all of those of you, especially the ones that have not had an MCI in their building, welcome. You're going to learn a lot. And today we get a special treat, like we always do every Friday, because we all have, we pride ourselves in the quality of these webinars. But today we have Deputy Commissioner Woody Pascal. Woody has been with us several Zoom webinars, as well as some of the a lot of our housing conferences. He actually not only comes himself to help us educate our residents, but he also deploys his staff. So for you guys to understand that if all of the folks in the rent administration office, they actually work for Woody. And all the orders that you guys get, hopefully the good orders, if you came through Palante, they're all signed by Woody Pascal. So I wanted to thank him for, again, because I'm sure there's a thousand of things that he can do on a Friday night. And the fact that he's here with us shows us a great commitment to education by DHCR and a great commitment of Woody personally. Because he clearly he can say, he has other things to do. So Woody, thank you. And second treat, and I'm honored as a woman. We found her, for those of you guys that joined us on the succession rights workshop, we find ourselves an attorney, thanks to Woody, at DHCR. And she's a woman, she's a woman of color. And to me, that's a very proud moment because we need people that are culturally competent, and to see what we go through. Not that that's gonna, sway her decision because of that, but it's, to me, it's an honor because she's here also helping us. And for that, I thank her. Her name is Sherelle Bernard, and she's terrific. So I'm not going to speak anymore. All I can tell you is that today's webinar is called "What is a Major Capital Improvement?" What that is what people say MCI. In Spanish, they call it MCI. At the end of the day, we're going to talk about what it is, right? What is this thing that we call MCI, and how do they work now, today, because of the new rent laws that happened in 2019. So without further ado, Woody, I'll pass you the mic. And again, thank you.
Thank you. Thank you. Can everyone hear me? You all hear me fine? Great. Well, first off, I want to say good evening to everyone. My name again is Woody Pascal, and I am the Deputy Commissioner at the Office of Rent Administration. I am here with my colleague, my special counsel, Sherelle Bedard, and we are very happy to be here this evening to talk about what is a major capital improvement and how the Housing Stability Tenant Protection Act of 2019 has impacted processing and what it means to you. Now, first, before I begin talking about what an MCI is, I think it's important that I kind of give you a high-level view of what the office is. First off, the Office of Rent Administration regulates rent stabilized and rent control apartments and landlord-tenant relationships in privately owned buildings. In New York City and its three surrounding counties, Nassau, Westchester, and Rockland, we regulate about 46,000 buildings and about 1 million apartments. We require owners to file something called rent registrations each year so that we can have a database of who are the tenants, their names, addresses, and some rents and lease information. We are a very unique agency because we function very much like a court, and we are application driven. So that means you can file a complaint, an application, an owner can file an application, and what we do is we serve it on both sides. So you as a tenant file an application with us, we serve the owner. Owner files an application with us, we serve the tenant. On those forms, people get to attach evidence, and then we then make a determination based on the law, our fact sheets, court decisions, and we issue something that's called an order, which is signed by a rent administrator. I'm not the one who signs those, but we have rent administrators in every part of the office. So we have one that deals with services. We have no heat, no hot water. That we have a rent administrator for that. We have somebody who signs off on overcharge complaints. You're saying that the owners are ripping you off. We have someone who does lease violations. And we have someone who does, well, the topic of tonight's conversation, MCIs. Now, with that being said, that kind of gives you a high level view of what the office is. Now let's talk about what is a MCI. Major capital improvements are building-wide improvements and new installations, and I have to say that again, building-wide improvements and new installations to build systems in the building, like a boiler, windows, electrical rewiring, plumbing, roofs. Anything that is unnecessary cosmetic improvements or work that's done in individual apartments, that is not impacting our decision regarding an MCI. Now, to be eligible for a rent increase for MCI, again, the MCI must be a new installation. And I have to stress that because it must be new, not a repair. So like let's say the owner says he wants to do the roof and he does half of it. He just puts tar on the ends. That is not what we would consider a new installation. Any claimed MCI cost must be supported by adequate documentation. You just can't say to us, hey, I put a new roof on and don't show us cancel checks. Can't give verify that the Department of Buildings or any other local municipality was involved in the process and issued permits. It's also important to note that for an MCI, it essentially must be for the preservation, energy efficiency, and functional and infrastructure of the building. Now, I'm going to ask Sherelle if she can kind of talk about quickly what qualifies as an MCI improvement or installation.
Okay, so what qualifies as, well, let's back up. So here at the agency, we have two very important forms. We have the Operational Bulletin 2021-1, which is our reasonable cost schedule. Everything that's contained on that reasonable cost schedule is what the owner has to adhere to when completing these major capital improvements throughout the building. So if you are wondering whether or not flooring is included, you will see a cost schedule for flooring. Flooring is a type of major capital improvement that is allotted in a building, provided it is outside of the apartment. So like your hallways, your vestibule, that would be a major capital improvement. And then we have what we call our useful life schedule, which is fact sheet 33. This tells you all of the replacement items that an owner can put into a building or replace in a building, and then it gives you the life schedule for it. So boilers and burners, that's a item that's necessary, right? We need heat in the apartment. We need heat in the building. That boiler, when replaced, should have a 35-year estimated life. If the landlord, for some reason, has to replace that boiler or that burner prior to the 35-year lifespan, their MCI will be reduced by the amount of years that is still left on that boiler. So if I spoke to Palente earlier this evening, and I explained what the fact sheets are, and I'm going to send those over. And I think it's very helpful if you are looking at whether or not your owner completed an MCI properly, that you look at these two forms. There are other items on here too for replacement. We have plumbing, repiping, we have windows, we're looking at roofs, and we also look at like the plies of the roof, right? Whether it's 2-ply or 3-4-ply roof. We have pointing, rewiring, doors, and that includes like apartment entrances, the lobbies, the vestibules, even down to the waste compactors on our useful life schedule. And on our operational bulletin, you'll see the per unit or the per foot or the per square footage that an owner is allotted to take in terms of dollar amounts, right? So if they're going to replace the roof and it's 30,000 square feet, they may only be allowed $100 per square foot for this roof. Mr. Pascal?
Thank you. That was very helpful. So basically, again, an MCI must directly benefit all of the tenants. It must meet requirements of our useful life schedule, and it must be applicable to rent regulations. Now, let's talk about what the old law is and what the differences are to the way it used to be. So the old law, the MCI rent increase was based on actual verified cost. And that's important. Actual verified cost. The MCI rent increase was also capped at 6%. Landlords could also temporarily collect a retroactive increase to cover the period between the date of the application and the approval date. Now, with the new law, off the bat, when the application comes in, tenants have currently 60 days to respond to the owner's MCI. MCI increases are prohibited for buildings with 35% or fewer rent-regulated units. MCI increases are prohibited if there are hazardous violations in the building. MCI increases, which were previously capped at 6%, is now capped at 2% and can only be collected once DHCR issues a written order granting the increase. There is no retroactivity, and the most important part is the owner must use our reasonable cost schedule. So, as I mentioned earlier, an MCI, again, was based on actual verified costs. So if the owner told us they spent $1.3 million and we could verify that they actually spent the $1.3 million, that's what was used. Now they have to use, by law, the reasonable cost schedule. So that kind of gives you the differences of what the law is. Now, Sherelle, did you want to talk about the cost schedule?
Well, I think I want to take it back one step. So you said that the tenant has 60 days from the date of the application. I think it's also important to mention that the owner has 2 years from the completion of the MCI to file his application. So just because the owner completed the MCI today does not mean that he's going to file the application today. He may take 2 years to get his invoices together and figure out exactly what it is that he completed and file that application within the 2-year period from the date of the last completed item. I think it's also important to mention when we talk about violations, and I'll use elevators as an example, if the owner has to go in and replace an elevator and he received a violation from the Department of Buildings, we will not issue a determination on that violation, well, on the MCI itself for the elevator until that violation has been cleared up. And there are 2 important times throughout our process that we look at these violations. So when we get the application in, we do an automatic search for violations so that we know what the owner is working with in terms of the building. And then right before we process and complete the order, we'll do another search and we'll look to see if there are any violations. If there are no violations at the time that we process that order, we will process the order. If a violation comes in 2 weeks after, unfortunately, there's nothing that we can do about it. The owner has already been issued the dollar amount that he's allotted for that particular MCI. And then looping that back into our reasonable cost schedule, the reasonable cost schedule was a new mandate, right? So in 2019, the legislature got together and they mandated that the Office of Rent Administration, the Division of Housing and Community Renewal, complete a reasonable cost schedule. And within that, we give the maximum costs that are allotted to each particular owner for what they can replace in the building under their major capital improvement. We worked tirelessly and effortlessly to get this reasonable cost schedule out. And it talks about what the owner can claim for landmark buildings, non-landmark buildings, It also talks about buildings that are 35% or higher, which is what Mr. Pascal was talking about. And we also use that reasonable cost schedule where the owner is required to complete renovations on a building that may be governed under another agency, not us. The reasonable cost schedule is extensive, and it breaks down in particular what the owner needs to file in terms of application, documentation that needs to be presented, which would be invoices, and in some cases, pictures. And we would review that information and then begin to process the application. Again, there's also in the back of the reasonable cost schedule, all of the items that are currently available for repayment if they choose to complete it. If the owner, by chance, completes a major capital improvement that is either more or not included on this particular list, they have the opportunity to file for a waiver. And what that's saying is that I completed the renovations for an elevator, right? And the office is only allowing $10,000 for this renovation, but it was an emergency situation. I had to complete it. It was last minute, and my renovations cost me $20,000. They would supply us with the information, the invoices, the application. We would look at it and then make a determination on whether or not they were in compliance and if they are due entitled to that $20,000. And the waiver is also for something, say that's not on the reasonable cost schedule. Boilers are on the cost schedule, but just say, for instance, it wasn't on the cost schedule and it's a major capital improvement. We need it for heat in the building. If it's not on there, they can file the application with additional information. This is a required piece that's required by the building for a heating component. It basically complies with what I'm supposed to do as an owner, but it was not included on your schedule. Am I allowed to be reimbursed for this particular item? We will look at it, they'll file the same information, and then we'll make a determination.
Thank you.
You're welcome.
Thank you. So again, MCI increases are effective and collectible on the first day of the month following 60 days from the mailing date of the order. So again, in the old days, when we issued an order, there was retroactivity. There's no retroactivity. So now what happens is once we approve an MCI, let's say I approve the MCI on April 1st. You have now until June 1st, or June 1st would be now the effective date of the increase, whatever that may be. MCI used to be permanent, part of your rent. Now, after 30 years, they're supposed to peel back and be removed from your rent. And that kind of gives you a high-level summary of what the old law was and what the new law is. Now, I want to kind of talk about something I know is not part of this discussion, but I want to throw it in there. Tenants will clearly always complain about MCIs and what the costs are and whether the owner, in fact, did the work or didn't do the work. And I think it's important to note that tenants can always challenge the approval or the application. But here are things that we look for, because what I've noticed is a lot of tenants complain about the affordability aspect of it. The things that we look for are were there defects in the installation of that item. So if the boiler is brand new and it doesn't work, potentially there's a defect. Is there improper cost documentation? Are there complaints of harassment by the owner? Are there outstanding maintenance or building violations of record? Is there a lack of building registration? Any DHCR ORA rent reduction orders and failure to meet the useful life requirements? Those are the things that we look for. We can't really address the issue of affordability. But again, we look for defects in the installation, improper cost documentation, complaints of harassment, outstanding maintenance and building violations, lack of building registration, rent reduction orders that we've issued, and the failure for the useful life requirement of that item. So I think I'm ready now for any questions. Is there anything else, Elsie, you want me to go over? We can't hear you. You got to unmute yourself. You're on mute. There you go.
Okay, I gotcha. Thank you. because I was going to carry on. So what you're saying, Woody, is that when the tenants receive that notification saying the landlord submitted an application,
Mhm.
that the responses that the tenants, you've seen some of the responses that tenants send, say, oh, I cannot afford it, my rent is too high. That is not, that is irrelevant to what the agency looks at. It's not
Correct.
looking at whether or not they can afford to pay, the increase, but it really looks into the points that you mentioned.
Right.
Repeat those points to me again.
It is installation. If there's
Everyone should be writing
defects,
this down.
yeah,
Yeah.
defects in the installation of new equipment,
Mhm.
improper cost documentation, complaints of harassment by the owner, outstanding maintenance and building violations, lack of building registrations, an issuance of rent reduction orders issued by us, failure to meet the useful life schedule.
So,
And it's also important to note, if the building does not, that the installation does not benefit all of the tenants, you got to tell us. You got to let us know. I'll give you a good example. Owner has a 6-story building. Windows were replaced. He only replaced them on the first 3 floors. Doesn't impact everybody. It's not going to be an MCI. Got it?
so if it's incomplete, is what you're saying?
Correct.
Okay.
Correct.
So an owner has to complete, if he's going to do an MCI for windows, he has to do all of the windows.
Correct. Correct.
Okay. And then what about the permits for, do you guys check on permits?
Absolutely. We check permits. Uh, there have been some challenges with our colleagues at the Department of Buildings, but we've been working with them.
Mhm.
But yes, they have, they have to have valid sign-offs for work that's being done. Certain types of work do not require permits.
Yeah. So what happens, and here's my question to you. So there's few buildings few tenants association that we've assisted in applying and responding to these MCIs before
Mhm.
the new rent laws. If the owner filed before the new rent laws and we responded before the new rent laws, and now with the changes, should tenants associations that submitted a response, should they modify their responses now with the new rent laws? I'm assuming that the case has not been decided upon. Of course, I should have been clear on that.
Right. Cheryl, you want to take that? And how we're applying the new law? Or how the
Well,
courts have determined that we should apply the law?
that goes back into, all right, let's start here, right? So if it's the old law and the MCI application was filed prior to the passage of the new law, we are going to apply the law at the time that the work was completed. I think the piece that carries over is the collectability, which would be 2% rather than the 6%,
Uh-huh.
because there's a caveat in the law that says landlords are only allowed to collect 2% of the MCI per year for the next 30 years. So they won't get that original 6%, they'll get the 2%. And with that, it will only be 2% on the next lease renewal. So if they get approved for the MCI and you're in the middle of your lease, the collectability for the 2% starts on the next lease renewal.
So
Oh, and let me go
if
back
could
because you
put it-
asked about amending their statements. If there's a mistake of law, there's a mistake of fact, there's an issue that they forgot to present, they can always send in an amendment. If provided they get a request for additional information, they can include that information within that amendment.
Okay, wonderful. Well, this is great. So just from your experience, from the paperwork that you guys seen, these are the key things that come to Palante. So I'm curious about it. I always have my questions, Woody, before we start opening up for the questions, right? Because I also learn. I also take this opportunity to learn myself.
Mhm.
In general, for let's say a 43 unit building, and they were to install a new boiler, what is the general cost? Like what's out of the market? Is it 300,000? Is it 400,000? What have you seen?
The costs vary. You can get a standard boiler, but the question then is, what else must be done as you are replacing that boiler?
Okay.
Is there any abatement that has to be done? Are you switching from oil to gas, which requires more extensive work because you may have to put a gas line under the sidewalk? Do you have to refit the chimney because of, again, this new installation? So it varies.
Mhm. And I think it's important also to know that some of these installations, as you like to call them, they're really based on what the New York City Council people, the laws that they're also passing.
There are, right, and that's one of the, I think one of some of the challenges that tenants are facing is that
Yeah.
it's not that the owner in some cases wants to do this installation. It's a mandate, and the government unfortunately is telling them they have to do it. And the law is that the tenant's going to eventually be paying for it.
Yeah, yeah. So for everyone that's listening in, basically, our city council members get together and they create these new laws. But in the city council, nobody says about who's going to pay for it. So, the city council can obviously say, well, we're going to give this landlord these grants, but they don't. What they're saying is, landlord, you have to do it. Otherwise, you get in trouble. Am I right, Woody? They'll get in trouble if they don't do it, right?
Yes, yes. I mean, and I'll use boilers as a good example of under, I think started under Bloomberg, they were switching from 6 fuel type, which is the dirtiest fuel type. And now a lot of them are going from 6 to 2, and then some are going straightly from 6 to natural gas.
And that's
So those are very,
private,
very
right?
costly, right? They're very costly things that have to be done.
What else? What else was passed on the council that the landlords are required to do? And obviously, the landlords can get their money through an MCI at a minimum level now.
There
For
is,
landlords,
and Sherelle, I know we talked about it once or twice.
I think the breaks, right? The
Will,
pointing.
yeah, well, there's building pointing facade work that has to be done every 5 years. That's been on the books for a while. In addition, there's something with the elevators. There's a
Yes.
kind of device that they have to put on the elevators to make them safer, so people are not continue to be decapitated.
Those are the new MCIs that are going to be coming in because
Yeah,
when that
I
came,
don't know what those prices are, but they're not as expensive.
okay,
But those are coming, and I know there's a local law 97.
7.
Want to talk about that one?
I knew it was coming. I was sitting here like, I hope he doesn't mention that. So, local law 97 has said that for buildings with 35% or higher rent stabilized and market rate buildings, we all have to comply with this energy conservation law. The energy conservation law says that these owners now have to retrofit their buildings to preserve so much energy between the years of 2030 and 2050. So those are key years to look at. What the owners are now doing is looking for a way to pay for these particular types of retrofitting. Some of it's going to come from financing from different companies. Some of it will come from different grants that are being offered by the federal government and even the state. The state has also put together an energy conservation law, and they're trying to work with these owners in order so that they can get some type of benefit for conserving energy. Um, there's a green space local law that's out. Don't quote me on the number at this particular time, but that's something else that owners are going to have to comply with over the city to create this green space. So we have energy, we have clean air, and it's pretty interesting of how it's taking form and how it's taking shape because um, every time they start to implement this new law, they reach down and they do an amendment. So originally it was just a certain subset of buildings between 25,000 square feet and then 50,000 square feet and higher in terms of lot size. And then maybe 2 months later after the passage, the mayor passed an amendment to the law, which included rent stabilized buildings. What they're looking at doing is seeing how this affects low income households too. And there are different incentives that nonprofits are working for to try to get like tenant participation and different ideas of like tenant incentives. If a tenant believes that they can own a part of this energy conservation company, they'll be more willing to foster this type of benefit for the owner. So that is where we are with local law 97.
Thank you.
You're welcome.
I know that understanding MCIs can be a little bit difficult for our clients, for our tenants. So we're gonna do something that's really unusual. We barely ever open up the mics for questions. So what we're gonna do is we're gonna just open up the mics for questions. We're gonna have one question. If the panelists, Ms. Sherella or Mr. Pascal, have a second question to the question, then we'll allow the tenant to ask the second question, the following question. So without further ado, I think,
Well, Elsie, let me ask you this because I see that some people went into the chat.
oh, I'm not even checking the
Q&A
chat,
part.
right?
That's right. There's a few questions in our Q&A.
Do you want to do those first?
Sure.
Sure, yeah, absolutely. Yeah, we could do that, absolutely. Robert, you're the boss on that.
All right. So one of the first questions that came in, I'm having several problems with my landlord. How do I go about filing a complaint with your office?
Okay. I don't know what the issues are, but let me give you our hotline phone number. It is 1-833-499-0343. Once again, the number is
okay.
1-833-499-0343.
All right. So that's in the chat.
Okay.
And assuming an owner is granted a new MCI increase amounting to $5 a month, the arbitrary amount. Now, as time goes on, the owner processes lease renewals according to RGB. After the 30-year MCI period, HCR rolls back MCI increase. Is the rent taken back? Is the initial $5 arbitrary increase, or would it include a portion of the increases over the 30-year period along with the $5 example?
So if I got the question right, we have a $5 MCI that has been applied to this particular apartment. It would actually fall off at the end of the 30 years, and the RGB increase would be on the base amount of the rent and not the base amount of the rent plus the $5 MCI.
Right.
Are MCIs that were granted before HSTPA now considered temporary and will expire after the 30 years? That's there's a three-part question. So it's, when the temporary MCI expires, does the legal rent get reduced? If so, does DHCR issue an order stating rents will be reduced? I'll repeat this question because there's a lot in it. What consequences would a landlord face for making false statements in its application?
Okay, so the first part of the question deals with MCIs that were granted prior to. So if the MCI was granted prior to the passage of the new law, and it goes back within 7 years, which would have been 2012 to 2019, they would get a reduction down to the 2%. They would keep that at the remainder of the 30 years. And once the 30-year process has worn out, well, not worn out, but the 30-year process has termed, that MCI would fall off. The MCI, again, once it's removed, the rent is reduced the amount of the MCI. The rent would not be reduced further than that. So it would be the base amount of the rent plus whatever RGB, Rent Guidelines Board, sorry, Daniel, increase that would be applied to that particular apartment. And we are talking about orders. And according to the new law, when the MCI is to term at the end of the 30 years. Currently, as it's stated, DHCR is to send out a notice to the tenant that their rent would decrease by the amount of the MCI at the end of that 30-year term. Consequences for landlords facing or making false statements and applications, that is something that we are working on. We are a regulatory agency. We do our best to implement the laws that are written. At this time, we do not process any applications or prosecute owners for filing false statements. If we believe that the statements are false, we'll ask for proof and an order can be denied.
Right. And I think in some cases, and there have been press accounts of this, is that owners have filed false or misleading statements with the Department of Buildings. It's not normally us. It's really like the Department of Buildings when they're doing their applications for major work that has to be done. So we refer them back to buildings for them to take action.
The question regarding the $5 increase from the MCI after 30 years, will the $5 be subtracted from whatever the current legal rent is at the time it expires?
Yes.
Mm-hmm.
What about the steam trap? Does that go under MCI? Landlord says tenants will not have to pay for it. Then who pays for it? And is it safe? What if you don't allow them to do it? Are there consequences?
So what do you mean steam? Is this a replacement of heat, of the heating system?
We'll wait for a follow-up possibly on
that. And the reason why I ask that is because the owner is required to give you heat. If he or she is going to modify the service to change from, in this case, steam radiator to something on a baseboard, he has to actually send us an application, which we engage all of you because they're modifying that service. So I'm
yes,
assuming
it's about
that,
heat. Yeah.
Right. Okay. Right. The owner has to, in fact, send a modification of service case to us, and then we will engage you regarding that process. You just can't do it.
And what if you rent from a private house?
MCIs are not valid on private homes.
Mm-hmm.
We are a regulatory agency, so we deal with rent stabilized and rent controlled properties.
Right.
Can this be a way that building owners use to raise rent?
I can,
Do you want to take
I
that?
think I can answer that. So historically, yes, there were things that they were doing that didn't necessarily weren't really necessary. Now I'll use an example with like 1131 Ogden Avenue. There was some stuff. That's why it's my favorite building. Yeah. There was some stuff that the landlord did because he wanted to do it to increase the rents. And I believe I might be wrong on the amount, but I think it was about $1.2 million, the MCI. And when he submitted the application to DHCR, we responded with the tenants, and DHCR only approved $99,000. So just because the landlord will spend it in an effort to increase the rents doesn't mean that it's going to, that he's going to win with the agency. Because like what he mentioned is that what exactly is it that they're looking at? They're not looking at whether you're being overpriced at your apartment. They are looking at the facts, right? What has been spent? And did he do the work? Was the work completed? And then it's legit, right? I mean, did you guys have your own research team, meaning DSCR? So historically, a lot of landlords were doing this, but then you got the city council that comes in with their own ideas about, oh, we want to do this, we want to do that, we want to do X, Y, and Z, and they're not really saying who's going to pay for it. Because it's very easy for me to come to your house and say, gee, I think you need to have marble floors. And you're going to tell me, gee, that's very nice, so you're going to give me the money. That's kind of the example here when it comes to, I understand that, I'm a tree hugger, I'm an environment, I love the environment. But it would have been great if the city council throughout these years would have designated who was going to pay for it, minus the tenants.
And it's funny you used that marble floor analogy, which is really very good. One of the things that we don't do at DHCR is work that was not necessary and is cosmetic in nature. We will not approve MCIs. So I'll use a lobby renovation is a good example.
Like Ogden, yeah.
The fact that you painted and put in new floors we're not going to give you any, you're not getting an MCI increase for cosmetic stuff. Because it does not benefit the tenants.
Exactly. And then, but I think, one of the good things is because of the pervasive abuse, I think, of some of these landlords, and I guess maybe even the overwhelming DHCR with all these cosmetic work and everything, there were groups, tenant groups, including ourselves, who fought for fairer MCIs, and we have this. But you have to understand, it's not just the landlord. There's different parts of this. There's the Department of Buildings, what they approve and they do not approve, because some of this work needs permits. We need permits. Second is what the city council is doing. And then third is what the landlord is really allowed to charge. So like Cheryl mentioned, you got a lifespan, like how long a boiler is supposed to last and things like that. So it's not that he can just go ahead and do it. They're going to try, but it doesn't mean that they're going to win. Robert, what's the next question?
If a landlord claims to have created an outdoor terrace for a building, but the terrace is not accessible by all tenants, would DHCR deny an MCI application for the terrace?
That's a specific case. We would need more information about it, but it wouldn't, in my opinion, be considered a major capital improvement. It's more a modification of services.
Has there been a notable difference in the number of MCI applications since HSTPA was passed?
Yes. And I think it's twofold. We had a surge of applications come in prior to the law changing, surge, hundreds of them. And I think as we were learning how to implement and administer the law, COVID hit. So all of our numbers are down, and all case types, the applications are down. So we're just going to have to wait it out and see what happens. But I think it's important to note, and again, I got to remind you this: the owner has upwards of 2 years to submit his or her application for an MCI. If they do not do it, it's grounds for it to be completely dismissed. So you got to pay attention to the date too.
All right, so I think one of the things we will be trying tonight is opening up microphones. So if you are ready with your microphone and you put your hand up with the hand signal, we will, and I see some hands coming up, great. So just keep your pace measured. Keep in mind that we do have an interpreter who is interpreting simultaneously. So I will start off with Sam, and I'm gonna unmute your mic, or ask to unmute. And Sam, you're live.
Oh, I'm live.
You're live.
Good evening, Sam.
Yeah, hi. I'm with the 66th Street, co-chairperson of the 66th Street West 88th Street Tenants Association in Manhattan. We submitted a challenge in July 15th, 2019 to an MCI for converting from oil to gas, and we haven't heard an answer yet.
Sam, at the end, what I'm going to do is, Alcia, can you give me Sam's information, and I'll check on that one for you, Sam. I'll see where it is.
Of course.
Okay.
All right, thank you very much, Sam. And
thanks, Sam.
We will move on to Althea. Althea?
Speaking to me, Elsia?
No. Hello, Althea.
Althea.
Oh, that's right. I thought it. I'm like, well, that's
sounds so.
Yes, Althea, you and I have spoken before, Alcia, and about the same question about the MCI that my not the current owner, but the previous owner had filed with DHCR. So we challenged it, and I went ahead and challenged it again, and they filled out the paperwork incorrectly. So DHCR returned the order saying that because they filled out the paperwork incorrectly, I didn't owe them any money. I had already paid them. So unfortunately, in the order that DHCR sent back to me, they didn't say that they needed to reimburse me. And I believe that I should be reimbursed because of DHCR said that it was filled out incorrectly and I didn't owe any money. That meant that the money that I had already paid should have been reimbursed. So I harassed the current tenant, the current landlord, the current owner for 3 years until just this month, he reimbursed me the money. When I spoke to Alcia, it was not a good time for Palante to work on it because they were working on the evictions that were going on because of COVID. At that time, she said that I should wait and I would get the money back. Palante would work with me to get the money back with interest. Now that the money has been repaid, would I still be eligible to fight for the interest amount?
That would actually be an overcharge.
Uh-huh.
And you should file an overcharge complaint and then have someone in the office, they will look at it in our overcharge bureau and see if, you are entitled to interest on the money returned.
Now, Althea, let me ask you this, because you said that we issued an order. Did you have an overcharge complaint with us, or what was it that?
Yes. So what had happened was when I wasn't sure if they were eligible for this. So my attorney told me to file an overcharge. And then they said, DHCR said it was correct. And when DHCR sent the owner the paperwork to complete, that's when they completed it incorrectly. And in the order that DHCR filed, they said that I should not have been charged for the MCI since the paperwork that the owner completed was done incorrectly. DHCR never said that the amount should be returned to me, but that's the way I read it.
Okay, Alcia, can I get her information so I can see what case type that is?
Sure.
It sounds like an overcharge, but it also sounds like an MCI. I'm not
It
sure.
was actually both. That's interesting. It was actually both because that's what DHCR said that I should file. I should file an overcharge based on the fact
The
that
MCI.
the
Okay.
MCI, yeah.
Okay. Let me get that information. We can
Sure.
take a look at that and get back to you next week.
Of course, thank you.
All right, be well.
Doing this.
Thank you.
I think we have one last question.
Yeah, we do have, I think Ethel had your hand up. Let me just look for you here one moment. And there you are, Ethel. With you. I mean, do you know? I don't have. One moment. See if we have an option here. If your mic is ready to go. Okay, so you are just unmute your mic and.
Okay, hi, how are you?
I'm good. Hi, Ethel. How are you doing today?
I'm good. It's so nice to see you. And I wanted to tell Palante, as well as the panel that's there, that you all are doing such a great job. I just wanted to let you know that, because this is knowledge that at least I know, and maybe if someone else asks, if they're in a situation, I can just say, hey, you need to do this. This is very helpful. It's very informative.
Thank you. Thank you. Thank you. Knowledge
You're
is
welcome. Oh, yes. Thank you so much.
Appreciate you. Thank you. Got any
All
more
right.
questions?
Sure. Yes. Josh, what are the best types of evidence, documents, photos, etc. a tenant can submit to challenge an MCI at the rent administrator level?
All of what you just said. All of what you just said. Because it sounds like, in some respects, Josh, that's who asked the question?
Yeah.
That you're saying that the installation of this new item may have been shoddy. All of that information is valuable to us. Send it to us. We do inspections of, the law requires us to do inspections of 30% of the MCIs, but we have strived to do about 50% of the MCIs, where we physically just go to the building and take a look and see if a new elevator was put in. But if you have that information and you're fighting the MCI, submit it.
I have the last question.
Yeah.
So, in Harlem, especially in central Harlem,
Mhm.
These landlords have gotten a liking to doing this new security system, new intercom,
Mhm.
where someone calls you and it rings your phone,
Mhm.
but the landlord's not paying your phone bill.
Correct.
Or is there?
That is that is a modification of services.
So that's why we're
We would consider that a modification of services, and in that case, we would in some cases, and I know I've seen them, where we've reduced the rent
yeah, that's
permanently because now you're putting the onus on the tenant on responding to somebody who's ringing a bell, where before it used to be a buzzer intercom system that was hardwired into the building.
great. So I'm gonna, I mean, layman's terms, you're telling me that if my landlord came in
Mhm.
and changed the intercom system, I'm paying a certain amount of rent, because now that intercom is ringing on my personal cell phone. I
Mhm.
can submit an application to
Yes,
DHCR and potentially get a rent reduction,
correct.
a permanent rent
It's
reduction.
correct. It's a service modification, and the owner was first off was required to actually apply to us to change this service, and this per tenant would get a rent reduction, permanent rent reduction.
That's key because a lot of our folks are not aware of that.
Mhm.
So Jacari is on the line with us. Jacari, we need to put that on the newsletter, because we're seeing a lot of that here in Central Harlem, where we've become responsible now. Our cell phones are the ones that are opening the front door of the building. So thank you, Woody.
Yep.
And this is great. I think, the more and more we learn about the complexity about these MCIs, the more as an organization, the more effective we are. But with the new rent laws and having you guys, Sherelle and Woody, explain the details to the point that we got today is extremely helpful. And I thank you
Thank
for
you.
joining us on a Friday.
Only I'll tell you this, only for you. You
Oh,
are,
Woody, thank
you are,
you.
and I'm going to say this publicly. I deal with hundreds of people, uh, every day. Um, I'm going to tell you for the folks in what I call Zoom
Zoom.
land,
Zoom land.
Zooming. Elsia is one of the most tenacious people that I've ever had the good fortune of working with. Although sometimes we agree to disagree, I
Right.
have nothing but utmost respect and admiration for the services that she provides to our community to try to make people's lives better, recognizing that housing is a right and that we all need it and we all should live in safe and decent housing. And I want to say thank you for your advocacy and your hard work.
Thank you, Woody. In your office, I'll bring it back to you when we were speaking last year, when it was, remember that time that it was really, really dark for us,
Mhm,
the
mhm,
March, where
mhm.
every 5 minutes we heard the ambulance passing by.
Right.
And, we as an organization and our members and our board will have to tip our hat to you guys because you guys were actually operating. I
Yeah.
remember that time that you
Yeah.
said, Elsie, I'm opening the mail. I'm like, like, come on, how does a deputy commissioner open up a mail of a such organization?
Yeah.
And you know what? That was our mail. Our mail was in there. I
Yeah.
guarantee you it was
Yeah.
there.
Yeah.
Because
It was mind-boggling. I mean, the first uh I'd say 6 or 7 weeks, it was me, Sherelle. There was only like 4 or 5 of us. And we were
wow.
getting 400 pieces of mail per day for the first like month. And some of the stuff could be literally 2 or 3 pages. And then some of the stuff was like a novel.
Yeah,
and,
yeah, yeah.
and it was really a lot of stuff. And you're like, oh my God, I can't take this anymore. I don't know how these guys do this every day.
Wow. Yeah, yeah, yeah. And then assigning these cases, because we're the impression that, well, with COVID, nothing is gonna happen. But your inspectors were out there with masks,
Mhm,
inspecting. We actually got a lot of rent reductions.
mhm,
That the inspection took place last year.
mhm.
And I thank you for that. We as an organization, we look at that. Because a lot of folks think, well, all this happened, nobody's gonna come in anybody's apartment, my case, my conditions, but your people, because these people reporting to you, they were out there and that's remarkable and very commendable. So I wanted to thank you and thank you for introducing us to Sherelle, okay? Because I mean she's I think and I hope that it's repeat that it repeats itself, that we could have your expertise Sherelle's expertise on the, with our audience, because we're not like the landlords, right? We can afford those big conferences, and you guys bring the conferences over to us even via Zoom. So thank you. I really
Anytime.
appreciate this.
Thank you.
Yeah, Robert, I think we could do the survey.
Sure, yeah, Jakari, if you have
Uh-huh.
that to bring that on screen, just kindly
Wonderful.
pop-up survey. Just take a brief moment to respond to those questions and let us know.
Great. And then in the meantime, what I'm going to do is I'm going to send Mr. Pascal Sam's information as well as Ms. Brown's information. No, Thea Davidson's information.
Yes.
Yes, well, I'm going to send them the information and via email tomorrow.
Okay. And then Daniel, and don't forget Daniel's information.
What's Daniel's last name?
Here, 66 West.
Oh, Daniel?
Oh,
Yeah.
No. That's Sam. Daniel is
That's Sam. Oh, that's Sam. Okay.
Mhm.
Yeah,
Okay.
that's Sam.
Sam.
That's Samuel to us.
Yes.
He's a member of our organization. So thank you so much, guys. Have a great weekend. And Woody,
Appreciate you.
Sherelle, Jakari, the entire Palante team, thank you so much for making time.
Thank you for having me.
Be well. Thank you for having us. Be well. Be safe.
Thank you. Take care.
Alrighty.
Thank you.